All right, let's discuss the Texas Realtors exclusive right to sell listing agreement. This is to be used after August of 2024's changes due to the NAR lawsuits. So this is the updated listing agreement. Paragraph number 1 are all parties, which means all owners. If your seller resided in the home with a spouse, then both parties must be on this listing agreement, must sign all paperwork for a contract. We are a community property state, so that's the law, regardless of whether the home is only in one name or not. Broker is going to be us, and then your phone number and your email. Make sure, too, for the sellers that I have a phone number and email on this form. If I can't get a hold of you, the first place I'm going to look is going to this form. I need contact information for your clients. Paragraph number 2 is the property. You're going to fill this in with the correct legal address. Legal address usually has a lot and block. So you'll put the lot there, the block there, and then it'll be, the subdivision, the phase, the section, all those go over in this big long space here. City and address go there. Improvements and accessories. Make sure you're talking to your sellers and explaining to them what all is included and expected to convey at closing. Agents get in trouble a lot because they don't set those expectations. If your client says, hey, I'm keeping the water softener, then under exclusion here is where you're going to put the water softener. But then you want to make sure you convey that in the paperwork on the listing and in the contract. I actually, if my client wants to exclude something, I make them remove it before we even go on the market. Top of page 2, it is or is it not in an HOA? You need to mark that. Listing price, it must have a price to be legally binding. You can always change that price later, but in order to execute a listing agreement, you need a price. You need a start and an end date. I recommend 6 months out, possibly more, given market conditions. Under compensation, this is the biggest change to our listing agreement. We will not use A ever. We will use B, and this is our fee for the listing agent only. We are not conveying commissions to another broker. Below here, it says seller paying buyer's expenses. In addition to paying our fee, seller, you may be asked to pay other fees. Have that conversation with them. Encourage your seller to agree to pay other fees. We want them paying the buyer's broker fee, but we don't want to be paying it. That's why it's not part of our listing agreement. There's a special place for this. We'll talk about it in a minute. Then it goes into how it's earned and payable. You need to understand what those paragraphs say. What happens if we breach? I recommend under E3 you add in if this terminates prior to the expiration date, then the seller will reimburse the broker for marketing expenses. I put $500 in there. That just depends, on the price point. Like a high-end home, you could be spending a couple $1,000s. I would put something in there. Protection period, 30 days. County is going to be Hays County on all listings. Number 6, listing services. I recommend you mark that we will put it in MLS, but we're not going to do it until we have the photos. So we're not ordering photos until the home's ready, Mr. Seller, and within 48 hours of me getting the photos, I'll make sure we're live in MLS. That's how I recommend you do this. The rest of this is pretty normal. You're going to need to make sure you understand all the paragraphs. It's giving us access, permission to access it. I use showing time. You may not want to use showing time, but I do, so I need to put it on there. Lockbox is authorized. Make sure you understand what the seller, what liability and indemnification means. Intermediary, we want to mark intermediary so we can show each other's listings in the office. Make sure you talk about intermediary, how it works. We always will do intermediary with appointments for our office listings. Then we're going to talk about how we want to offer financing. Usually it's conventional, VA, FHA, and cash. If you are listing a condo, make sure if you put VA, FHA, or conventional that it can actually qualify for this financing. You can get a lot of trouble if you list the wrong one. Then back under compensation, paragraph 5, it talks about this. Seller does or does not authorize the broker to share with the other brokers that they're willing to pay money. I would recommend you do. That way in MLS you can say, yes, we do offer money towards other things. Those other things can be closing costs, it could be an interest rate buy down, or it could be commissions, or it could be all of the above. If your client wants to get specific on a dollar amount, you would use Texas 1412 and specify that amount. That amount is only at a full price offer. Anything off of full price, that amount would not apply, and it's all negotiable. Make sure your seller understands that. In MLS, we only have yes or no as far as are we offering other funds. So it's not required, but since this does say use this form if they mark does, then you should be prepared and have that form ready to fill out. But again, just explain to your seller that amount is negotiable just like any other term of the contract. Okay, let's see. Make sure you understand the liability limits. Mediation, of course, is in here, just as all our contracts are. Make sure you understand the additional notices. You want to make sure you can explain to your seller everything that's in this. Foreign person, you need to make sure they are or not. I didn't mark one of these. But if they are, then you need to make sure you notify title immediately. If they are, and make sure they understand that they are subject to a withholding for taxes. The federal government charges a tax to foreign sellers of property in the United States. Okay, guys, I hope that helps. This is the signature page, us with our license, and then you would sign as broker's associate, and your license would be down here. I hope this helps.